In the next slides, I'm going to be going over cases having to do with real estate. In other words, these are clawback cases where real estate is involved somehow. And the point of it is to give you a concept of how clawbacks are dealt with in the context of landlords or liens or anything to do with real estate. And it's always helpful to know that because special issues may arise when real estate is involved, and it's always helpful to know how precedent cases were resolved. This is a pretty old case out of Georgia, but I wanted to include it because it illustrates a very, very basic and common defense to a clawback action for landlords. If you take nothing away from this entire video, you should remember this defense to a clawback. So, like I said, it's a Georgia case. There's a landlord, there's a tenant. Things go south. Tenant doesn't pay because tenant is having financial problems, obviously. And then there's a demand and some collection pressure, and there's a demand for a wire. And the tenant suddenly pays and then files for bankruptcy within 90 days, here a couple of weeks later. So what you have here is you have an unsecured claim by a landlord, you have collection pressure, you have non-ordinary activity between these two, and it looks pretty bad for the landlord. As far as ordinary course, there is no ordinary course defense here, basically, which is the most common defense folks like to use. Well, trustee thinks probably I got a slam dunk over here and moves for summary judgment, and the landlord objects and also cross moves for summary judgment. The landlord's defense is contemporaneous exchange for new value. So how's that possible? How is that a contemporaneous exchange? The rent is due June 1st, and the tenant wires money June 29th. That's almost a month apart. So this is the recitation of what you need to show in the for a contemporaneous exchange defense. There's new value exchange between the parties. Both the creditor and the debtor intended for the parties to be contemporaneous, and it was substantially contemporaneous. So how could this be substantially contemporaneous? The reason it works is that the landlord is continuously providing new value to the tenant because the tenant is continuing to occupy the premises. And it's not like someone sold bananas to the tenant on June 1st and then the tenant paid June 29th. Here, there's a continuous transfer of value to the tenant, and so case law basically accepts that in this situation, there's a contemporaneous exchange for new value. And also, it's noteworthy that the payment was within the month that the rent became due, and that also helped to make it contemporaneous. So that's important to know in the context of landlord-tenant clawbacks. This is another new value defense case. This is a fairly older case. Eastern District, Pennsylvania. And here you have a landlord, you have a tenant gets late, and then the parties agreed that as a condition precedent to a new lease, the tenant has to get caught up. So the tenant did get caught up, goes bankrupt, and the landlord is sued for a preference. Trustee argued that the new value contemporaneous exchange exception doesn't apply because the only thing the debtor got as new value in exchange for the payment of the arrears was a new lease, and it's not, trustee argued that wasn't new value. The landlord argued that that was new value. A lease extension is valuable, otherwise the tenant would have had to incur the cost of moving, etc., etc. Well, the court's decision was that, and this was an appellate court, this is a district court, and the district court decided, yes, lease extension can be new value, can also be a contemporaneous exchange for new value, even though the new value in the form of the lease was going to come 25 days after the after the payment of the arrears. But nonetheless, the court said this is possible. But then the court said, but I don't know what this lease is worth. I mean, it could be worth more than what was paid in arrears as contemporaneous exchange of new value, but I don't know what it's worth. So he remanded it back to bankruptcy court to decide what the fair market value of the new lease was. And the takeaway here is, with the contemporaneous exchange defense, you've got to give something of new value in exchange for payment. And here, it's not clear that the lease was worth the payment of the arrears. This case involved a debtor leased property from a defendant. Ended up, I'm calling him a defendant, later became a defendant in a preference case. It's a fairly recent case. And what happened here is that the landlord applied a security deposit and also drew on a letter of credit obtained by the debtor, with the creditor as the named beneficiary, $62K and change. So it was paid this money by the bank during the preference period. The lessor brought a motion for partial summary judgment just on that issue. The debtor argued that the payment to the creditor was an indirect preference because it was a payment that essentially came out of collateral set aside by the debtor. And so it was an indirect payment. That was their argument. The defendant argued, no, it's not an indirect payment. That money belonged to the bank. The bank paid us, and if you want to sue somebody, then you sue the bank. The court granted the creditor's motion, the lessor's motion. A letter of credit is not avoidable because it's not the debtor's property. A letter of credit and the proceeds are not property of the estate, and a bankruptcy trustee is not entitled to enjoin a payment of funds under a letter of credit. So it has to be. The takeaway here is the payment has to be property of the estate of the debtor. I mean, here it wasn't. It was property. It was the bank's property. So the defendant won on summary judgment in this particular circumstance. This is a fairly recent case involving another landlord-tenant relationship, and I found the outcome to be a little bit surprising. So what happened here is guy wants to open a bar. He enters into a lease for the bar space, applies for the bar license, and then doesn't get it. So he had put a deposit with the landlord, and he asked for it back, and the landlord, being an honorable landlord, sent it back to him. And then the landlord filed Chapter 11. Of course, the trustee was appointed at some point, and the action was started to claw back the deposit that was paid to the tenant. The tenant asserted, hey, this was kept in escrow. It's a security deposit and segregated escrow account, and it's not property of the estate. Never went into the estate. Never should have gone into the estate, and it's my deposit. So that should be and also this is all in the ordinary course of how landlords and tenants do business. So it should be dismissed. Well, I was surprised by this. The bankruptcy judge basically said, first of all, Mr. Defendant, your facts are wrong. There was nothing in the agreement saying that these funds needed to go into escrow, or that they were held in escrow, or that they were segregated. In fact, the agreement says exactly the opposite, that the landlord doesn't have to hold this in escrow or segregate anything. And it was just paid out. It was commingled with other monies, and it was paid out from a general bank account. And there's insufficient evidence to support the proposition that. And by the way, this was a motion for summary judgment by the defendant. So the judge said there isn't enough evidence here. Go back to the drawing board and find some if you want. That the security deposit that was paid back to you was not property of the estate. And the court also said maybe it was ordinary between the parties, but there isn't enough evidence. And at this time, this is a case that was decided before 2005. The defendant also had to show that this was ordinary for the industry. And the judge said, no, you really haven't shown that. So if you want to try to show that, you're gonna have to get more evidence. Summary judgment denied. That wasn't the end of the case. I assume there was probably a scheduling order setting a trial date, and who knows, maybe there was more discovery. But live and learn, and it is certainly good to learn that a security deposit, in fact, and in certain circumstances may not be segregated. It may not be held in escrow. And in fact, the agreement between the parties may specifically say that. And once it's commingled, it's very hard to say that these are trust funds or that they're not property of the estate. This case presents a fact pattern that's very, very, very common, and the law is not really clear on it. And I'll go into the facts in a second. But basically, the fact pattern is as follows: subcontractor is paid by a general contractor before the general contractor goes bankrupt, and the subcontractor has a right to put a lien on the owner's property, not the general contractor's property, the owner's property. And the subcontractor gives up that right. So in other words, the general contractor says, look, I'm going to pay you, but you have to relinquish any lien rights that you have on the property. And the sub says, fine, what do I care? Pay me and I'll release the lien rights. Then there's a bankruptcy filing by the general contractor. And the subcontractor says, well, subcontractor is sued for a preference and says, well, I gave new value, and the new value I gave in exchange for being paid was I waived my lien rights. So let's see how that worked out here. So this is a 2007 case, and it's pretty much the same situation. Debtor was a general contractor. Creditor was a subcontractor that supplied concrete, and the entire project was secured by a bond to ensure payment to, among other people, all the subs. So the creditor the subcontractor finished the work and issued lien waivers to the debtor, the general contractor, and got paid. So the owner, in this case the town, made payments to the debtor, and at some point debtor goes bankrupt, and trustee brings an action against the subcontractor who was paid during the preference period. And the argument is, hey, you're just like any other vendor, and you were paid more than theoretically other people are going to be paid in the Chapter 7 case. So hand it over. Well, of course, and this is the standard defense, the subcontractor said, well, I supplied new value in exchange for getting paid, and the new value was I gave up my lien rights. And the question is that going to be a defense? Well, the court looked at all the case law involved and noted that just giving up your what's called inchoate lien rights, because your lien rights are really gone. You gave them up, and they're inchoate because you got paid. You didn't follow up. Perhaps you didn't perfect your lien rights. Why? Because you got paid. So it's called inchoate lien, a lien right without an actual corpus, you might say. Anyway, so the court looked at the case law, and the court concluded that a lot of cases, and the court chose to follow this line of thinking, a lot of cases say that if the debtor is still owed money by the owner, then this defense works. And why is that? Well, the thinking is as follows. If the subcontractor didn't get paid and put a lien on the project, the owner is going to sue the debtor for indemnity. Now, if the owner still owes the debtor money, then it's going to assert a set-off against the debtor of the amount that the subcontractor is demanding from the owner. In bankruptcy, a set-off becomes a secured claim. In other words, if the owner set off the amount by which it had to pay the subcontractor in the 90 days prior to a bankruptcy, that would not have been avoidable by a trustee, because a set-off is given special status as a secured claim, so it can't be avoided. So, long story short, you can get the defense if the owner still owes money to the general contractor. This is a 1909 South Dakota case about the ability of a trustee to avoid the liens of a landlord on agricultural property. And I think it has limited precedent value for bankruptcy cases involving assets and companies in urban areas. But anyway, it's just an example of a lien type case. So the landlord entered into lease agreements with, I assume these are farmers. They're leasing out, the landlord is leasing out a lot of land. And in the lease, part of the lease specified that the landlord would have the right to have a lien on the property in case rent wasn't paid. There was a bankruptcy filed by the tenants. I guess all the lessees filed for bankruptcy in this case for some reason. And then there was a summary judgment to avoid the landlord's liens on this property. In other words, this isn't a typical clawback case. It's more of a lien avoidance case, but it's somewhat similar. Well, the landlord argued that these were consensual liens and that they can't be vacated. The debtors argued that these are statutory liens under 545, Section 545. Section 545 says specifically statutory liens, liens given by statute, and specifically to secure rent, can be avoided by the trustee if there's a bankruptcy. So in other words, wiped out. They can be wiped out. Avoided is a fancy way of saying that. Well, the court agreed with the debtors here, and the liens were wiped out. And I guess the takeaway in this case is, if you're going to, and this applies not just to liens for rent, but other statutory liens. Statutory liens are in danger of being avoided in a subsequent bankruptcy. On the other hand, non-statutory liens, liens that are entered into voluntarily and explicitly by both parties and properly perfected, those liens are not avoidable. Well, depending on the circumstances, but they may not be avoidable. So the takeaway is, if you're going to have a lien, make sure it's explicitly voluntary by both parties, and make sure it's perfected, of course. That's a whole different section of the Bankruptcy Code on when a perfected lien can or cannot be avoided. This is another lien case, 2005 in New York. This is a subcontractor asserting a mechanics lien. And it's the same argument. So subcontractor is sued for a preference. Trustee tries to avoid it, and the subcontractor says, "Hey, I could have had a lien. If I hadn't been paid, I relinquished the lien." And this is different from the last case because we're not talking about avoiding a lien. We're talking about avoiding a payment that, if not paid, would have been protected by a lien. So it's different. And basically the law here is that if you had the right to a lien, if the subcontractor had the right to the lien, in other words, what the court does is look at state law. It's not bankruptcy law that determines lien rights. It's state law, and the bankruptcy judge has to apply state law. So he's going to take a look at the state law and see whether you would have the right to file a lien. In other words, did you miss any deadlines yet? Did you fail to take any steps? If you failed to take steps or you missed a deadline to file a lien at the time that you were paid, then you can't argue, or at least in the interpretation of this line of cases, you can't argue that you're giving up anything. It was gone. You didn't have anything to give up. So the point is, if you had something to give up, if you still had the right to perfect the lien, which is all hypothetical anyway, because you did get paid. So again, it's the flight into the hypothetical. So hypothetically, if you didn't get paid, you had to have the right, which hypothetically you would have pursued if you hadn't been paid. It's a little crazy, but it's a great defense, so I have no complaints. This is really a great line of cases for defendants, because otherwise they wouldn't have any defense most of the time. So this is it's not specified, by the way, in the Bankruptcy Code. This is created by case law. This is created by smart lawyers and understanding judges. At any rate, the issue here, as I described at length, was could this subcontractor have filed a lien? So the court took a look at the New York State law to see if he could have. That's basically the same argument that I just went over. Well, the court made an interesting decision. Basically, the court looked at everything and said, yes, um, this particular subcontractor would have had the right, if it hadn't been paid, to place a lien. And the court said it doesn't make any sense, or would put subcontractor in a ridiculous position to not accept payment and then put a lien, and it would be unfair to put them in that ridiculous position, so that the law that the court adopted, the rationale for the decision, is not new value, which I'll get to in a second, but it's simply the principle that if a lien that could have been placed is not avoidable, in other words, if the subcontractor could have put a lien on and that lien was not avoidable, then the payment that relates to that hypothetical inchoate lien is not avoidable either. That's simply the principle. It's a little bit of a tortured rationale, but that's the rationale. And the reason it's a little bit tortured is because the court basically said forbearance is not new value. Obviously, this line of cases that this court is following do not want to set a precedent wherein forbearance is considered some kind of new value. And the reason for that is probably you'd have defendants using forbearance in non-real estate cases, in all kinds of cases, and it would be bad precedent because it's too vague a concept of new value, and new value has to be something concrete. So at the end of the day, actually in this decision, the defendant won partial summary judgment, and there were some other factual issues that had to be resolved. But he was certainly well on his way, and that's an important principle to remember if you're ever sued for a preference and you think you might have had the right to an inchoate lien. Of course, the first thing you got to find out is, did you have the right? This is another lien case, Court of Appeals case, 10th Circuit. It's a fairly old case, but it's the highest court in that circuit dealing with this issue. It's still good law. So this is sort of a wrinkle on the lien line of case protecting avoidance of payments made to contractors and subcontractors. Anyway, so this is Oklahoma, and the appellant, originally the defendant in bankruptcy court, put a lien on the property, in this case certain oil wells, and it was properly perfected, and if he had left it there and then was paid, he would have been a secured creditor, arguably, and wouldn't have had a problem. But something happened. The debtor applied for a loan, and the bank refused to give the loan unless the lien on the well was released. So the debtor paid the defendant, now appellant, and the defendant agreed to remove the lien. Unfortunately, the debtor paid for this during the preference period, unfortunately for the defendant. And so there's an issue of whether this is a preference or it's not a preference. The argument made by the defendant is, I had a lien, I released the lien, I was paid, and it was sort of the standard lien argument. You paid me for release of the lien, and therefore I should be treated as essentially as a secured creditor and can't be a preference. Well, the trustee made an interesting argument here, and this comes up quite a bit. And the issue is, well, you had a lien on the oil well, but it turns out the oil well had no oil in it, or whatever. It had no value. So you released the lien, and then I paid you good money during the preference period. And this is really the trustee arguing here, obviously. And standing in the shoes of of the former, I assume the former owner of the debtor, since this isn't involuntary, by the way, and says, look, you didn't have a lien because your lien was valueless. It was a lien on nothing. A lien on nothing is worth nothing. So the question is, is a value, should the defendant have submitted an appraisal of the well and therefore prove that his lien had value in order to prevail here? So that's the question. The defendant argued, well, it's a contemporaneous exchange for new value. Again, this is a little bit different from some of the other cases. He's not saying it's a subsequent new value defense. In other words, he's not saying I gave value afterwards, but he's trying to use the new value defense in some kind of way. And what he's saying is it's contemporaneous exchange. Why is it contemporaneous exchange? Because I released the lien and you gave me money for it. And the trustee is saying, well, you released nothing, it's not worth anything, so what you gave had no value, so it's not a contemporaneous exchange. Well, the court agreed with the defendant appellant and found that it was a contemporaneous exchange and evaluation is not required. Why? Because release of the lien had value for the debtor at that time. Why did it have value? Because they got the loan. Actually, I don't know if they got the loan or not, but they certainly were able to submit a better application for the loan. In other words, releasing the lien, whether the lien had value or not, had value to the debtor at that time. And the court didn't go into the valuation issue of how much that value is worth, but the court decided it was equivalent value for whatever reason. Maybe there was testimony as far as the value of the loan, of getting the loan or applying for the loan. Anyway, it's a good thing to take away in the context of real estate, in the context of liens, in the context of being sued for a clawback and coming up with yet another argument why a payment in exchange for a lien. If you come across or you're in a fact situation where a lien has to be paid in order to apply for a loan or to get a loan, which has to be a very common situation, certainly I would certainly use the reasoning and the precedential value of a Court of Appeals case like this. Well, this is another lien case. There are a lot of lien cases because there are a lot of situations where that lien defense is going to apply. Here, this is a case out of Texas, 1987. And in Dallas division. And Cimarron, the company that filed for bankruptcy, was in the oil and gas business and owned a couple of wells in Hood County, Texas. Consultants, who are the defendants and the appellees, provided geological services to the debtor during various times. They invoiced the debtor properly, and they got paid by the debtor properly, and the checks cleared. Unfortunately, debtor company went bankrupt, and of course they're sued for preferences because they were paid during the preference period. And the question is, should they have a right to use the incoherent lien defense? What they're saying is, we didn't take any affirmative efforts to perfect liens on either of the wells. Why? We didn't have to. Why should we do that? It would be insane. We got paid. And we didn't also, and the trustee pointed out, hey, they didn't specifically relinquish or actually release a notice of lien or do anything. In other words, they didn't take any action to relinquish a lien. And so what the trustee, of course, in his arguments is applying, this is forbearance, and forbearance can't be new value. Forbearance is not new value. Just saying you're not doing anything is not providing any value to the estate. You have to do something. And here they didn't do anything. They didn't do anything. So the bankruptcy, and of course, the defendants are arguing, well, we had incohate liens, and we gave them up, and that's new value. So we shouldn't be sued here. It's just not fair. We would have been secured creditors if we kept our liens. Bankruptcy court found for the consultants, saying the payments, saying it was new value. It was new value. It didn't go into a lot of detail about it, and the debtor appealed. Again, an incohate lien is that's great, but it's not new value. It's some kind of forbearance. Well, the higher court concluded, and this is, by the way, I believe the district court concluded that it was new value, but again, the district court had the same rationale. It's not for forbearance and waiver of an incohate lien is not new value, and we're not going to make that precedent. But it's simply unfair that if you had the right to put a lien, and they did have the right, then the payment made in the same transaction, in which transaction, if you hadn't been paid, you would have put a lien. It's not fair. It just doesn't make any sense, and it puts the defendants in a ridiculous position. So it granted the defendants right to assert the incohate lien defense, but it's not the new value incohate lien defense. It's just the incohate lien defense, because the court specifically found that no new value was applied. It's basically an equitable defense. This case is not really a clawback case, but it is, in a sense, very similar, because it's a case where the trustee filed an adversary proceeding to determine the extent and validity of liens. And so it's sort of similar, because basically the intention of the trustee is to wipe out notices of liens, and it's similar to voiding a lien pursuant to the clawback statutes. I'm just going to go over it quickly as an issue that can arise. This is a Western District of Kentucky case. It's also an older case. And the defendants obtained judgments against the debtors before the bankruptcy case was filed. Debtors filed Chapter 7 petition December 16th, 1982. And before that, the defendants tried to enforce their judgments through a series of levies. And these are the attempts to enforce their judgments. And the issue is, were they successful? Do they have perfected liens? And this is the issue raised by the trustee of whether these are good liens. Well, it turns out they're not good liens, and the process was not filed in Kentucky. And this another good example is that what is the bankruptcy court doing? It's looking at Kentucky law. There's no lien law in the bankruptcy code. The bankruptcy code provides that if you're going to make a determination as to property rights, you look to state law. So that's what's being done here. The court's looking at Kentucky law. And found that none of this conduct resulted in valid liens, and so the lien, these liens these purported liens were avoided, wiped out, however you want to call it. They didn't exist anymore after this ruling. This is another lien case, sort of. It's what I call a payment bond case. It's a 547b5 case, and I'll explain what all that's about. But I have to say, I love this case because this is a case where you have a judge really bending over backwards for a defendant. Either that or you have just a great lawyer arguing very persistently and creatively for the defendant. Probably a combination of both. But as defense counsel, most of the time, I have to say, this kind of case is very encouraging. So this is another Dallas case, and it involves an attempt by a trustee to avoid payment to his subcontractor as a preference. The subcontractor was doing excavation work for a publicly financed commercial construction project in Texas. Anyway, check clears, gets paid, and the debtor deposited the funds from payments from the owner into its general market account, its general money market account. So why is that important? This is why. The defendant comes up with a couple of arguments, and one of the arguments is that these are trust funds. In other words, under Texas property law, the debtor held these funds in trust for the defendant in the context of performing excavation work. The statute says, debtor, you're being paid by the owner of a property. You're a general contractor. If you hire a subcontractor to work on this, when you get paid, you're holding this money in trust for the subcontractor. That's the law in Texas. It's obviously designed to protect subcontractors. It's not your money, general contractor. Can't just do with it whatever you want. You got to funnel it to the subcontractor so he gets paid. These are trust funds. Well, the court said, you're right, there is a trust. These are trust funds. So they're not shouldn't have been property of the estate because they were held in trust. Problem is, you can't trace them because what actually happened here is that the debtor stuck everything into its general account, didn't segregate anything. So it's impossible for this subcontractor to identify which funds were held in trust for this particular subcontractor. You can't trace the funds. If you can't trace the funds, the trust argument goes out the window. It's useless because you can't trace it. And so the judge said, well, you don't have that, unfortunately. You don't have that defense because you can't trace anything. However, the judge did say, you have a 547b5 defense. What does that mean? Under 547b5, one of the elements the trustee has to show. What is that? The trustee has to show that the payment received would result in the recipient getting paid more than it would have been paid in a hypothetical Chapter 7 case filed at the time of the transfer. 547b5. I love this code section because it requires the judge to come up with a hypothetical, and it's unbelievable how far from reality these hypotheticals get. And so here the judge is saying, well, there was a payment bond here. In other words, the general contractor, before it got awarded this job, I'm sure the government said to the general contractor, we're not going to give you the job unless you get a payment bond. So we know the subs are going to get paid. We want insurance. We want a third party to ensure that subs are going to get paid. And the general contractor said yes and got a payment bond. So here there was a payment bond. So what's the hypothetical? If the subcontractor was not paid, then it would have gone to the guarantor. It would have been paid anyway in full. Wouldn't have been paid less in a Chapter 7 case. It would have been paid in full anyway if there was a Chapter 7 case. So according to this hypothetical, and assuming that if it hadn't been paid, hypothetically it would have applied for a payment bond, and hypothetically the guarantor would have paid the subcontractor. So assuming all those hypotheticals in the hypothetical world came true, then the trustee essentially failed to show that that the subcontractor would have been paid less in a Chapter 7 case. It would have been paid hypothetically exactly the same. So that was the defense that the judge granted, and it's an important defense. It's an important thing to know. Why? Because if you're being sued for a preference, and there's a guarantor guaranteeing payment, then of course you're going to make the argument that hypothetically you would have been paid. Not all courts are going to follow that argument, and there are a lot of different fact situations where a court is not going to go out on a limb like that. But this one did, and it's possible in another case you'll be or I'll be able to use this case as good precedent. It's certainly a very creative argument, and it's certainly something worth knowing. It was also an ordinary course of business defense, but it didn't apply. This is a fairly old case from Florida, but it illustrates an important defense and an important principle in the context of the real estate business. Case was filed in Bankruptcy Court, Fort Myers. Debtor was a general contractor. Again, this is a situation where a general contractor is paying subcontractors on a building project. The debtor, you can look at the slides. I'll basically summarize it by saying the debtor got into a lot of trouble and defaulted on a lot of stuff. What happened here was that the owner, obviously concerned, I think, with their liability if the debtor didn't pay subcontractors, paid for material furnished by the defendant, the subcontractor, by cutting checks both to the debtor and to the defendant. Anyway, these checks were filed. These checks were deposited in the debtor's bank account. Debtor goes bankrupt. Trustee sues and wants the money back. And the defense is an interesting one. Basically, the defense here is called the earmarking defense, and it was agreed by the judge that the defense was applicable. And the defense basically says you have a third party, you have the owners cutting a joint check to the debtor and the subs, and clearly the intent of cutting a joint check is that the sub is going to sign off on the check and that the sub is going to be paid. So you have a third party directing and controlling how the debtor is theoretically controlling at any rate, how the debtor is paying the monies that this third party is paying to the debtor. So essentially the debtor is a conduit. And the argument is that basically This money never became part of the bankruptcy estate. Debtor's just a conduit. Debtor's a pass-through. The owners wanted to pay the subs and issued a joint check, and that's exactly what happened. The payment went to the subcontractors. It was deposited first with the debtor, but obviously the intent of the parties was that the debtor was going to be a conduit here, and that this was not supposed to go into property. These payments were not supposed to be kept by the debtor in any way, shape, or form. And so the court found that this was in fact the case, and that these funds were earmarked, and that the payments were not avoided. There was also a new value defense here. I'm not going to go into it. It wasn't the main issue. Also, you might note that one of the checks bounced. Obviously, if the defendant doesn't get the check, then the preference case has to be dismissed for that, and it was. Well, here's a good example of similar fact pattern, similar argument by defendant, and the opposite result. So this case is another real estate related case of North Carolina, 1996 case. This is a district court level case. It's an appeal. Accord Group was the debtor, the general contractor, specializing in renovating offices. The debtor, Accord, was hired by Rexwood to be Rexwood's general contractor. And the debtor, Accord, hired Code Electric. It's the defendant and the appellant here. So those are the parties. What's interesting here is that the debtor received a check. Obviously, the owner, Rexwood, realized that there was a financial problem over at Accords, and so it issued a check, a joint check, to both the debtor, Accord, and Code, so that to ensure that Code would get paid. Code did get paid, and the debtor filed the Chapter 7 bankruptcy. After Code was sued for a preference, it made an argument that this was not property of the estate. You had Rexwood cut a check to a joint check to Code and Accord, obviously earmarking the payment to Code to make sure Code would get paid, and so it was not property of the estate under the earmarking doctrine. Well, the court, and this is the appellate court, had to decide if the bankruptcy court erred in finding that this payment was property of the estate, and it decided that the bankruptcy court didn't err. The payment was deposited by Accord in its own account, and the payment by Rexwood to Accord was noted in its bookkeeping records as being a payment to Accord, and the court basically denied the earmarking doctrine here. It did not find enough evidence that this was not a property of the estate. This is an important case for a very specific principle. It's a Sixth Circuit case, Court of Appeals, and basically what happened here, and this is a situation that can happen again and again. You have an owner, a general contractor, a subcontractor, and a subcontractor to the subcontractor. So what happens when the general contractor is dealing with its subcontractor? The subcontractor under it is not paying the third subcontractor, and the general contractor declares the first subcontractor in default and pays the second subcontractor directly. What happens when the first subcontractor files a bankruptcy? Can the trustee avoid a payment that theoretically should have been made to the first subcontractor, but was made to the second subcontractor? Can the trustee for the first subcontractor avoid that? Well, let's take a look. So this was a case in 1986. The state of Tennessee entered into a contract with Schenkel. And this was for a building project. And Schenkel entered into a contract with Arnold for electrical work. And Arnold bought supplies from Braid. So anyway, Arnold basically fails to do its job properly according to Schenkel. Schenkel declares Arnold in default, takes over Arnold's work on the project, and then pays Baird directly. So in this slide, I basically go into the payment, that a payment was paid directly to Baird in a little bit more detail. Bankruptcy, the middle subcontractor, Arnold, files a bankruptcy petition, and the trustee asked the bankruptcy judge to declare that the payment to Baird was property belonging to Arnold and could be clawed back from Braid by the bankruptcy court for the creditors of Arnold. And so that was the issue that was at stake here. The bankruptcy court found for the trustee and decided, yes, this is property of the estate and could be clawed back. The Court of Appeals found that the bankruptcy court erred and declared that the original general contractor, Schenkel, had an obligation to pay Baird, an independent obligation to pay Baird directly, and that this was not property of the estate. So it's and reversed the clawback decision. So Baird kept the funds. So this is an important precedent in this kind of multi-subcontractor situation. And this is an example of a multi-subcontractor situation. This is Eastern District of Michigan, a 1997 case. Pretty similar to the case we just looked at. Geodynamics general contractor retains, it's abbreviated UST as the subcontractor, and UST retains Zorn as the sub contractor. And the defendant was providing fuel storage tanks for a construction project. UST, the middle subcontractor, didn't pay the defendant the full amount. Instead, Geo paid that amount directly. UST files for bankruptcy. The trustee sought to claw back the payment from Zorn that was paid directly by Geo. Well, the argument, of course, by the trustee is that this money belonged to UST and therefore could be clawed back by a trustee. The defendant cited the Arnold Court of Appeals case as well as the Miller Act. The trustee tried to the trustee tried to distinguish the Arnold case by saying that there wasn't an independent contract obligation, but this was a voluntary authorization by UST, which would distinguish it from the Arnold case. And the judge said it doesn't matter. That wouldn't preclude Zorn from successfully invoking the Arnold case, and also that the contractor had an obligation, another obligation under the Miller Act to pay Zorn. So clawback case was dismissed.